Well, hello everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm the Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host this webinar on FCC Enforcement Bureau reform. Our moderator today is Scott Delacourt. Scott is a partner at Wiley, Rein, where he advises clients on developing and implementing regulatory strategies and represents them before the Federal Communications Commission and Federal Trade Commission. Before that, he was the Deputy Bureau Chief and Chief of Staff at the FCC's Wireless Telecommunications Bureau. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. After our speakers give their presentations, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window. We will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Scott, thank you so much for joining us, and the floor is yours.
Thank you, Caroline, and thank you for joining us. Our topic today is the Supreme Court's Jarkesy decision and the implications for federal agencies, particularly the Federal Communications Commission. We have an all-star panel to talk with us about this topic today, and I'll take a moment at the start to introduce them to you. I'm going to give abbreviated introductions. They all have many accomplishments, and you can see their full bios on the Federal Society's website. To start with, we have Professor Richard Pierce. Professor Pierce is the Lyle T. Alverson Professor of Law at George Washington University. His scholarship focuses on administrative law, and he is the author of over 20 books and 130 articles on administrative law, government regulation, and the effect of government regulation on market performance. Next, we have Tom Johnson. Excuse me. Tom is my partner at Wiley, and he co-chairs the Issues and Appeals practice. Tom has held a number of high-level government positions, including most recently as General Counsel of the FCC. And finally, we have Travis LeBlanc. Travis is a partner at Cooley, where he co-chairs the Global Cyber Data and Privacy practice. Travis has also held a number of high-level government positions, including, as relevant to today's discussion, as Chief of the FCC's Enforcement Bureau. Well, to start things off, let me just give a little squib for our listeners about the Jarkesy case and what it involved. The case involved a securities fraud case, a securities fraud claim brought by the Securities and Exchange Commission through the agency's in-house enforcement process. After hearing an administrative law judge, before an administrative law judge, the FCC imposed a monetary penalty of $300,000. The judgment was appealed to the Fifth Circuit and ultimately the Supreme Court, which held that imposition of a monetary penalty via the FCC's in-house enforcement process violated the Seventh Amendment right to a jury trial. The court held that in cases involving private rights that are legal in nature and akin to suits at common law, the right to a jury trial attaches. The right to a jury trial does not apply in cases involving public rights or equitable relief. And so what we'll talk about today is, what the implications of that SEC decision, SEC-focused decision may have for other agencies, in particular the FCC. But maybe to start with, Professor Pierce, could you tell us how should agencies that engage in enforcement or have in-house enforcement tribunals think about Jarkesy? Are there particular enforcement practices that are at greater risk or in need of reform?
Yes, there certainly are particular ones that pose a significant risk under Jarkesy. Jarkesy changed the way of drawing the line between public rights and private rights in two important ways. First, the court recognized that the cause of action at issue in Jarkesy is not a common law cause of action. The court said it's both broader and narrower than a common law cause of action. But it concluded that it actually concluded that the Seventh Amendment, but the case law is the same with respect to this issue under Article 3. So under both Article 3 and under the Seventh Amendment, it was initially to be classified as a private right of action rather than a public right of action, because as you characterized it, it's akin to a pre-existing common law cause of action. The court actually used 6 different characterizations of the relationship between a common law cause of action and a statute law, the statutory cause of action to be not susceptible to adjudication by an agency, but mandatorily subject to adjudication only by an Article 3 court, and depending on the remedy requested in a jury trial. Each of those were very vague descriptions. Akin to, the one you used is one of them. There's 5 others in the opinion. The one I like particularly is traced its ancestry to the common law, but they also have, it contains some of the soil of the common law. So it's very, very murky in terms of the relationship between a common law cause of action and a statutory cause of action that would cause a court to classify the cause of action initially as a private cause of action. And then the second change that the court made was that it then said, when a matter from its nature is the subject of a suit at common law, Congress may not withdraw it from judicial cognizance. And that is a contradiction of what the Chief Justice, who wrote this opinion, said in his opinion in 2011, quoting his opinion there. He said, Congress can convert a cause of action from private rights to public rights in cases in which the claimant issue derives from a federal regulatory scheme, or in which the resolution of the claim by an expert government agency is deemed essential to a limited regulatory objective within the agency's authority. So there's 2 big changes here that dramatically expand the class of cases that are on the private rights side of that private rights, public rights distinction after this case. And the critical question that any agency should be asking, and that any reviewing court is going to be asking under Jarkesy, is just how much of a relationship is there between the cause of action that the agency is pursuing in the action it's taking through its use of its in-house court. How close is that relationship to the common law? And I think a lot of classes of agency adjudications, probably hundreds, are going to fit within this new, much broader definition of public rights as some cause of action that traces its ancestry to the common law. And in those cases, the agencies are not going to be able to use their in-house adjudicatory systems. I don't know enough about the kinds of cases that FCC adjudicates through its in-house adjudicatory process to have any idea how many, if any, of the FCC's adjudicatory decisions are likely to fall within this new, much broader definition of private rights that can only be adjudicated by an Article 3 court, and if the remedy is legal instead of equitable in nature, only through use of a jury.
Well, thank you for that, Professor Pearson, and that's precisely why we have Tom and Travis with us. They can tell us more about how the FCC's docket actually works and what the workload actually looks like in terms of a private right, public right kind of breakdown. But maybe we'll start with Tom, having served as the general counsel at the FCC. What is your take on Jarkesy and how it impacts the FCC's enforcement process in particular?
Yeah, well, thanks a lot, Scott. I think, as Professor Pierce was saying, there's a lot of different formulations of what the test in Jarkesy is going to be going forward and how that's going to play out. And so I think a lot of, I think how broadly this impacts operations at FCC is going to depend in large measure on how the courts moving forward interpret the holding of Jarkesy. And a lot of Jarkesy talks about how there's sort of two elements to a cause of action that the courts have analyzed in the past to determine, is this the kind of cause of action that has its roots in the common law and would require a jury? The first is the remedy. And with respect to the civil penalties that were at issue in these SEC proceedings, the court said that civil penalty remedy is all but dispositive here. And what the court was basically saying was that an intent to punish, a punitive damages type remedy, was a type of remedy of common law that could only be heard by a jury. Justice Sotomayor in dissent seemed to think that was a very broad-reaching holding. The Justice Sotomayor mentioned had a list of agencies that she believed were impacted by this decision, including the FCC, agencies that had similar sort of civil penalties regimes. And if so, you take the remedies discussion in this case, and if you say that that's what's doing most of the work, again, what the court said is all but dispositive, then that's pretty broad reaching. If you look at how the FCC imposes civil penalties, sometimes reaching into the tens or hundreds of millions of dollars, deciding where to assign, just much like the sentencing guidelines in federal court, they have discretion to determine where within a statutory range they're going to impose a penalty for each offense. And they look at willfulness, right? And willfulness actually has its roots in the statute. Was this a willful right violation to impose a civil penalty? How egregious was the violation? All of these factors. I mean, it's clear that the civil penalties of the FCC are designed to punish, not merely to compensate the victim. It's many multiples of what you would impose to compensate the victim. So if what we're looking is remedies, then a broad amount of what the FCC and other federal agencies do is now called into constitutional question. Now, the court goes on to say this is confirmed by the analogy that they had in that case between the SEC securities fraud claim and fraud claims at common law. I think a big question moving forward is how much work does that part of the opinion do and how much work will that do going forward? As Professor Pierce alluded to, there wasn't this precise similitude between a common law fraud action and the federal securities fraud action. So the court is saying it doesn't need to be on all fours. It's just confirmed by the analogy, right? And so a lot of FCC actions are going to have some elements of the common law to them. If you consider, for example, a hot topic today, privacy and the scope of the commission's authority under Section 222, which deals with customer proprietary network information. And you can imagine analogies to common law invasion of privacy or breach of contract or conversion of consumer information or things like that. So is it enough to be able to point to those analogies to say that plus the civil remedy puts this in that area of private rights? And there is the public rights exception. And what you see that the FCC is already doing, Scott, in an enforcement order last week, where two of the dissenting commissioners, the Republican commissioners, say, we really need to look at all of this with an eye towards whether or not Jarkesy impacts our civil penalties authority. The commission has this discussion, this footnote, where it basically says, we think that much of what we do falls within the public rights exception and has no common law analog. So obviously they are going to be pushing very hard on this idea that what matters is whether there's a common law equivalent to the claim and whether it fits within this public rights exception. Now, what I would say when the court gets to the public rights exception, it starts pretty much the same and says, well, is there a root in the common laws? Is the type of thing that would have been decided at common law in 1789? The court says, once again, we look to remedy, we look to whether there's a common law analog. Again, this is the kind of thing that should have been held by a jury. The court says there are these historical exceptions, and it made clear to labor. It said that this is an exception to the rule. It can't just be that Congress creates a new statutory scheme and it gets public rights protection. And you need to determine whether the exception is justified by this long historical pedigree predating the founding of deciding these types of things outside of the ordinary Article 3 process. So things like customs, things like tariffs, where you can point to sort of a colonial era history in which these things were adjudicated in tribunals, sort of administrative tribunals, not Article 3 courts, then the public rights exception might apply. It's not, to my mind, not really possible for a regime, a New Deal era regime in the 1930s, amended in 1996, dealing with new technologies, new communications technologies, that you can really find that historical pedigree predating the founding, in the court's words, to apply the public rights exception. But that's going to be the big debate moving forward, as to how much work are these different parts of the opinion really doing.
So Tom has characterized the private rights scope of the FCC's work as fairly large, and public rights is fairly narrow. Travis, I wonder, given your experience running the FCC's Enforcement Bureau, what are your thoughts on how well the FCC's processes stand up in the wake of Jarkesy, and what do you think about the need for reforms?
Well, thank you, Scott, for the question, and also for moderating this conversation today with Richard and Tom and yourself. I very much look forward to the engagement. As mentioned by Caroline at the very beginning, I know for myself, at least, I'm here in my personal capacity, and just wanted to make sure to say that. Tom is smiling, so I'm assuming that he is as well, but one never knows, as you might imagine, with those in private practice. With regard to the question about the FCC's enforcement penalty regime, I do not believe that it is unconstitutional as currently formulated. I think it's important to start by recognizing what the Jarkesy decision is and what it's not. Importantly, it is not a ban on enforcement outside of courts. I think there's some confusion that after Jarkesy, you can do no enforcement whatsoever, and that every federal agency needs to come to a halt until such time as it fully works out everything enforcement. That's not what the case was. Secondly, it is not a ban on non-fraud penalty cases. This is what the good professor was speaking about earlier when he said that what this determination is going to turn on is whether there are, non-common law ancestry to the fines. And to the extent that it's outside of the analogy to the common law, it's outside of the fraud context, penalties can continue as they did before the case. So I disagree with Tom that any civil penalty would be covered. I don't think just the mere fact that an agency is penalizing suddenly means it's outside of the scope. The Jarkesy decision was about the SEC's anti-fraud provisions. That's what it was about fraud. So to the extent that we're talking about the extent of the ruling, it really is about fraud-based penalties. I also think it's important to note that public rights enforcement fines are clearly okay. We can have a debate about what is the scope of public rights, but there can be no question that the public rights exception to the Seventh Amendment was reaffirmed by the Supreme Court in Jarkesy and will continue to exist. Additionally, administrative proceedings can continue to be used for seeking injunctions. There's no question about that. So to the extent that an agency is seeking to pursue enforcement outside of Article 3 courts and outside of a jury trial for injunctive relief, that also is okay. And then lastly, I'll note that settlements are perfectly fine, as they were before. There may need to be some tweaks to the language of the settlements, but there's, again, no issue with the concept of an agency reaching a negotiated resolution, voluntary resolution with a defendant. So with that in mind, we can sort of look at the FCC's enforcement regime to examine whether or not the extent to which, insofar as it is seeking to enforce a fraud type penalty, whether it is constitutional or not. In my view, it is for two reasons. The first reason is that the FCC's enforcement activities fall within the public rights exception. And the second reason is that even if it did not fall within, even if the FCC's enforcement activities did not fall within the public rights exception, all defendants ultimately are statutorily entitled to, and the FCC is required to follow through a jury trial before a fine is actually imposed. I'll talk through each of those a little bit to provide a little more analysis. On the public rights exception, as both the professor and Tom acknowledged, Jarkesy recognized Congress has the discretion to assign cases involving public rights to non-Article III courts, such as administrative courts within the subject matter expertise of the agency. This is a long-standing exception to the Seventh Amendment, permitting the use of Article I courts to enforce public rights. The case that sort of kicked this off is Murray's Lessee versus Hoboken Land, which is from 1855. And I actually think there's this temptation for people as they interpret Jarkesy to only want to look at it in kind of the abstract. But there is a history there, a lot of case law that looks at public rights versus private rights over the last almost, 2 centuries, coming up on 2 centuries at this point. And that law really does provide some insight into what the Supreme Court's jurisprudence has historically understood as enforcement of public rights. And one way of seeing that has been, and it's a line that goes all the way through, that it's a federally created privilege is an example of a public right. And a federal example, a classic example of this is actually a land grant would be a classic example of this. There can be no question that the FCC is responsible for administration of federally created privileges. Think about it: spectrum, broadcast, public lands. I mean, they fit together. We often speak about the FCC's licensing as being around the public commons, of the spectrum. Any rights that any communications provider has are entirely a product of Congress. They are privileges that provided by Congress and ultimately intertwined in a comprehensive regulatory scheme. Moreover, the communications networks that we all use and rely upon are clearly critical channels of interstate commerce. Congress, when looking at its authority, is at its height when regulating them. It is, in fact, exercising its plenary authority as recognized by Congress. Communications channels also invoke Congress's paramount authority over national security, including the nation's defense. They are critical infrastructure. There is just no question that when we're speaking in the context of the FCC and communications networks, we are talking about Congress at the height of its authority. And that is different from when Congress is clearly acting in a commercial capacity, which is what we actually saw in the SEC context. Here with the FCC, there is no common law analog for the overwhelming majority of FCC enforcement actions, if not all of them. To be clear, the FCC enforces public rights as well understood within the court's varied history of public rights jurisprudence, and Jarkesy did not upend all of that precedent that's been sitting on the books. This is distinguished from the securities issues raised in Jarkesy. As I mentioned, those were about anti-fraud previously. There, Congress was regulating commercial activity over which Congress does not have complete, unfettered, plenary control, unlike communications networks. The second reason why I believe that the FCC's enforcement regime is permissible under following Jarkesy is that even if we were to conclude that the public rights exception did not apply, the forfeiture orders that the FCC issues only can be enforced after a de novo trial before a district court. And therefore, defendants are not deprived of their Seventh Amendment rights, and the Article 3 court is ultimately the final decider on what the law is. It might be helpful at this point to provide a little background on the FCC's enforcement process as a general matter. Typically, because the FCC's process is not the same as every other federal agency that is out there. Typically, an FCC enforcement matter begins with an investigation that is conducted by the Enforcement Bureau. If the Enforcement Bureau does not settle the matter with the defendant, then the Enforcement Bureau has the ability to propose a notice of apparent liability, an NAL, which essentially is the commission's statement that they believe that there may have been a violation of the FCC rules conducted by the defendant. Now, the NAL, depending on the authority that we're talking about, the amount of it, the nature of it, can be decided by the Enforcement Bureau chief, or in the vast majority of scenarios, it actually goes to the commission for a vote. If the commission votes to issue an NAL, then it will order a defendant to file a written response within a certain amount of time. Once the defendant files a written response to the NAL, then the commission usually would consider whether or not a forfeiture order would be warranted. That is, to adjudicate the response on the basis of the facts as developed by the Bureau and looking at the response as received from the defendant. And the commission will then issue what it calls a forfeiture order. And in other agencies, that might be the end of the enforcement process. But at the FCC, that's not the end. Aside from the fact that sophisticated defendants may very well go and seek reconsideration through a variety of administrative measures, we'll set that aside for a moment. The typical process to actually enforce or to recover on the enforcement order by statute under Sections 504 of the Communications Act requires the Department of Justice or the Attorney General to pursue an enforcement action in a federal district court, in an Article 3 court, where a defendant is entitled to a de novo trial. This is all statutorily required before a fine can be imposed. Alternatively, a defendant has the option of paying the fine temporarily while they can go directly to a court of appeals. But either way, that fine is not paid until a court makes a decision. So no matter what, no matter how the administrative side of the FCC acts, there is a right to an Article 3 court. There is a right to a jury trial, and that fundamentally transforms the difference between the FCC and other agencies. So I provide that background because what it makes apparent is that FCC forfeiture orders are not self-executing, and by themselves are not enforceable. Nor can they be used against defendants in any agency proceeding unless they are paid or there's a court adjudication. That is written into the statutory regime under the Communications Act. The FCC's role in the enforcement process actually, I think, is analogous to the Federal Magistrates Act that permits district court judges to designate magistrate judges to handle certain dispositive motions and then submit any findings or recommendations to the district judge. A district judge is required to do a de novo review, same as in the FCC, if either party objects to the magistrate judge's report and recommendations. The Supreme Court has already upheld this because the ultimate decision was left to a district court judge. So in sum here, even if even considering the narrowed, limited scope of Jarkesy's impact is more likely to affect the enforcement regimes of other agencies than the FCC. As I shared previously, the public rights exception does apply to the FCC, but even if it didn't, the FCC process already builds in a statutory right to a jury trial. I'll stop there, Scott, because I think, I do wonder whether, actually, let me say one other point, because I think it's important. I do wonder whether at the end of the day, it actually is better for defendants to have jury trials. I mean, let's just think about how this plays out. There are lots of bad facts that come out in an FCC enforcement proceeding. All of this now is going to be aired in public for everyone to see. This is more likely for plaintiffs' attorneys to find them, other regulators to read them. It's much more than a FCC commission open meeting, which I know everyone who is participating in this session dutifully attends, but it's totally different from the type of scrutiny you get when you're actually in a court. Juries are unpredictable, and that is a factor at play. Communications regulations and laws are extremely complex. To put those in the hands of, a normal, of a fact finder that doesn't have the expertise that an agency like the FCC has, I think, again, may not fare the way that a lot of defendants would like. The courts are slower. They take a long time. Although, I will admit in 2 seconds that the FCC's administrative law judges could move a little bit faster. The fact is courts are slow. They are very expensive. And the way that some companies may take advantage of changes in administrations, not as easy in a court as it is at the FCC when suddenly you have a new majority that comes in. So all of that's to say, I think the current process that the FCC has does survive the scrutiny of Jarkesy, and I'm not actually sure that the result that others may see coming from Jarkesy is actually one that a lot, if not the vast majority of companies would actually hope to achieve at the end of the day.
Well, there's a lot there, Travis, and thank you for that. Just to summarize it a little bit, I think you've characterized the FCC's docket as largely being enforcement docket as largely being based on the public rights side of the ledger, and focused on the fact that a forfeiture has to be tried before a district court before it can be collected. And then you raise there at the end the idea that folks that are defendants before the FCC's Enforcement Bureau may prefer the FCC process as opposed to a jury trial for a variety of commercial reasons. But Tom, I want to give you an opportunity to react to that as well. So Professor Pierce, I see you've got your hand up. I'm going to have Tom go first, but then Professor Pierce will come to you.
Well, thanks, Scott. Well, I guess I'll start with maybe some of the things that Travis said at the outset about kind of the scope of the ruling and sort of its practical impact, because I do think that that's important. I think Travis is right that empowering juries to decide these cases doesn't take away from the Enforcement Bureau other tools that it has at its disposal. I mean, this decision is about the commission's authority to impose civil penalties, and so the commission would retain its authority to impose other penalties that aren't legal in nature. And I think the commission would continue to have the authority to impose to issue cease and desist orders, for example. And I think some of the things that Travis was talking about concerning licensing, for example, you're just talking about a license revocation proceeding that doesn't have civil penalties attached to it. I don't think that type of proceeding is implicated by Jarkesy. Might be other problems with it, but I don't think that that's a Jarkesy issue. Part of the problem that the FCC has that you don't have at the SEC and the FTC is that Congress did not, at least clearly, give the commission the authority in the first instance to pursue these types of claims in court. The SEC and the FTC do have that authority. In fact, as this Jarkesy case was working its way through the system, the SEC started changing how it did business. It started putting fewer of these cases before the ALJs. It started bringing more of these cases before Article III courts initially. So this is something that would require congressional reform to change, but at the FCC, there isn't that avenue for immediate relief. There's only that opportunity for back end judicial review, which I'll talk about in a second. But part of the problem is that under this current system, I think there's a lot of concern among the regulated community that there's sort of an imbalance of power. You're stuck for a long time before the Enforcement Bureau, and that really starts at the investigative stage in terms of how the extent to which the Bureau can seek extensions of the statute of limitations to continue to impose discovery and investigate claims against regulated entities. The scope of those discovery requests, which aren't immediately reviewable, the types of behavioral conditions that the agency can seek in consent decrees in exchange for reducing penalties amounts, and no real avenue, at least during this stage of the case, to review how are you calculating those penalties amounts, how high are those penalties amounts. So you sometimes end up with these consent decrees that, in addition to civil penalties, have these behavioral conditions that the FCC might not be able to impose as a matter of its own statutory authority outside of the consent decree context. And so you have very limited ability. If you care about your relationship with the FCC, you have very limited ability to challenge a lot of these decisions that are happening at the enforcement stage. Because remember, Scott, it's not the scofflaws really who are engaging in these good faith negotiations with the FCC. A lot of the civil penalties that are imposed on bad actors under the FCC's regime actually go uncollected, because these are the folks that are not acting in good faith. They don't have a long-standing relationship with the agency. They may not even be located within the United States. So it's really the companies who care about law enforcement and compliance that end up getting involved in these negotiations with the agency, but end up getting hit with and paying a lot of these massive penalties. Now, I would submit it's not sufficient, given the way that this is structured, for the regulated party to have this back-end Section 504 review that Travis was talking about. I mean, sort of as an initial matter, not all courts abide by the rule that this is de novo review. There are some courts that review the commission's factual findings deferential for reasonableness. There are other courts that say that all that we're looking at here are the facts. The Fifth Circuit, for example, says we're not looking at the legal justification. We're only looking at the facts. Now, maybe those are wrong, but at least in some courts, folks are not getting that kind of comprehensive de novo review once the Department of Justice brings that action against you to recover the forfeiture. But moreover, I would argue that if a federal agency is imposing all of the costs associated with an administrative proceeding, which typically at the FCC, unlike in Jarkesy, it's not an ALJ. It's not even the protections of the ALJ. It's the Enforcement Bureau doing the investigation, essentially issuing the complaint, which is called the Notice of Apparent Liability, and then being heavily involved with, if not drafting and releasing, the forfeiture order at the end of the day, acting as the decision maker, the fact decision maker. And you can just see how similar a lot of the forfeiture orders look to those initial notices of apparent liability. Overwhelmingly, a notice of apparent liability resolves in a forfeiture order. You don't see a lot of opinions in which those charges are just dropped, or it turns out that the company was right all along, or the target was right all along. So at the end of the day, you're still left with a forfeiture order, an order of the federal government that imposes whatever reputational damages that imposes, whatever disclosure requirements under federal and state law we need to say, like, here's risks that we have outstanding, here's outstanding orders of the federal government, and you're putting a target in the position where it needs to violate that federal order, where it just needs to not pay it, and then wait for the Department of Justice in its discretion to pursue you in order to finally get your jury right, which may never happen. I think there's something like a 6-year statute of limitations. It might be off on that, but in any event, it's time where you have a legal cloud of uncertainty around you, where in the ordinary course, what might be a legal process would be just much like the Department of Justice. There's an investigation. That investigation resolves in an indictment or it resolves in a complaint. And that is the initial document that sets off the process before an Article 3 court with all of the protections of the federal rules of civil procedure, all the protections of the federal rules of evidence, and the protection of a neutral, life-tenured adjudicator in an Article 3 judge. I mean, Travis mentioned the magistrates. I mean, the magistrate process is working its way out in the context of an Article 3 court with all those civil protections, and ultimately with oversight by an Article 3 judge, not in the first instance before an administrative tribunal that lacks a lot of those protections. So agency did mention that footnote I talked about in this enforcement order. Now that this is a big issue before the commission, made the same argument Travis made about 405. So 504. So this is going to, I think, again, be another issue of litigation in the courts. One thing that I've been advocating for, Scott, is that we can try to avoid a lot of this collateral litigation by going to Congress, seeing if we can get some legislative reforms around this so that we don't have all of this collateral litigation over the next 5 years, or to have industry and the commission sort of sit down and think about, are there reforms that we can have at the FCC that will level the playing field a little bit and reduce any of the kind of due process type concerns that juries were designed to protect, Article 3 courts were designed to protect. And as you see, Commissioner Symington, for example, called for that proceeding in his recent statement, saying, I'd like to see a proceeding to kind of take a look at what the impact of Jarkesy is on the FCC, and should we be making any changes to our processes before continuing to impose civil penalties. So I think a lot of this is just about, are there ways to level the playing field? As Travis said, I mean, you can always waive the right. You can always waive the right. You can choose to proceed at the FCC. You can choose to issue into a consent decree with the FCC. But at least under the current framework, you can't demand an Article 3 court. You can't demand you can't demand a jury. And so the question is, should that change? And should Congress address it? And could the FCC take some steps to address it?
Well, thanks, Tom. And Professor Pierce, you've been very patient. I'm going to give you a chance to react to that.
Sure. Let me start with the various points that Travis made. So I agree with the one point that rarely are you going to see anybody opting to exercise a Seventh Amendment right. Generally, that happens in there's a jury trial in less than 1% of all civil cases filed in the U.S. Hardly anybody actually wants a jury trial, and so I don't think there's going to be very many of them requested. But having the right to jury trial is one of the many points of leverage in the settlement process, the negotiating process. So it really matters a lot. What matters far more is, for my purposes, trying to figure out whether the agency has the power to use its in-house adjudication system to resolve various enforcement disputes, is the Article 3 question. I agree with Travis that in his description of the rich history in this area, when I teach this subject, as I do every year, and I write about it on a regular basis in books and articles, I discuss 9 cases. Now it's going to be 10 cases. And the 9 cases that I discuss are entirely consistent with Travis's description of the pre-existing law, and they're actually, I think, quite sensible. Unfortunately, Jarkesy changes that. As I interpret Jarkesy, it makes massive changes in how we define public rights versus private rights. And the public right, private right distinction has been the basis not just for the handful of jury trial Seventh Amendment cases, but all the many Article 3 cases. And so I reluctantly disagree with Travis's description of history as a predictor of the future. I think Jarkesy just changes all that. Now, the most important way in which Jarkesy changes that is through this. What the court says quite clearly is if the cause of action, the statutory cause of action, traces its ancestry to the common law. God knows what that means. If it does, then Article 3 applies, and then the remedy determines whether the jury trial right applies. Okay, that's a second step, logical step in the decision-making process. As I interpret the opinion, if the cause of action traces its ancestry to the common law, whatever the hell that means, then an agency cannot use its in-house process to resolve a penalty dispute. Now, both Tom and Travis focused on the money damage, money penalty aspect of the case. And I certainly agree that the holding relates only to that. However, the reasoning is exactly the same reasoning that the court has been using in its Article 3 opinions for the last over a century. And so unless the court changes that reasoning, this is going to apply to equitable remedies as well. I disagree with both Tom and Travis on that. The holding applies only in this case, the Seventh Amendment holding applies only to monetary penalties imposed by agencies. But the court's reasoning in all of its cases, whether it's equitable remedies or monetary reasoning, all of the reasoning is based on public rights versus private rights. So the change in the way that the court defines public rights versus private rights inevitably is going to affect the availability of all equitable remedies as well as all legal remedies. We're going to see those cases. I think there's already been a couple filed where those cases are going to percolate through the courts. And then the big question, I think, in case after case after case is going to be how closely does the statutory cause of action, how much of the common law is buried somehow in the statutory cause of action. And there's, I get back to, I don't have the expertise in FCC adjudications to have any view on that, have any idea whether Tom's views are right or Travis's views are right. But you're going to see that litigated in tons and tons of cases. I had one other thing. I agree with Travis that if there is available a complete de novo review, including a jury trial, then this has no effect on FCC. I don't have the expertise to get into the difference of opinion between Tom and Travis on whether there's actual de novo review that takes place and is available. I will say also that is very, very rare there's very, very few agencies where the de novo review is available for any action they take. In almost all cases, what we're talking about is limited scope appellate review, and I'm sure that would not satisfy the court. So there are two aspects of the debate between Tom and Travis that I don't have the expertise to resolve. One is the extent to which the FCC's statutory causes of action in enforcement cases are based on or have some common law element in them. And second, whether there actually is de novo review available in those cases.
Well, Professor Pierce, that's a wonderful jumping off point. And we've received some questions from the audience, and one of them asks, in light of this difference of opinion, what's a responsible steward of an agency supposed to do? So put yourself in the position of leadership at the FCC, and you have to conform your enforcement process to the Jarkesy decision and do some risk mitigation, determine that either you can side wholly with Travis and say the process is not in need of reform and continue to conduct it as you're doing now, or you can take more of Tom's view and say, at least a portion of our docket appears to be based on private rights and is at risk. If we go ahead with our process as it is, we're subject to legal challenge. How do you handle that? What would you do? And I'll maybe give Travis the first shot at it.
Well, I'm willing to take a shot as the Enforcement Bureau Chief, but you have a former Enforcement Bureau Chief, but you have a former General Counsel here. I think the obvious answer to your question is anytime the Supreme Court or a federal court issues a decision that calls into question any of an agency's activities, you got to look at it. I mean, that's what you have to do. Doesn't mean that you have to, fundamentally reform everything every time there's something, but you got to consider. It's apparent to me that the commission at the highest levels is already doing that, right? We have a statement from the chair. We have two of the minority commissioners raising concerns. It's being, and I have no doubt that the general counsel is looking at this. That's going to be privileged. It's not going to play itself out necessarily in the public domain for all of us to see. But I do want to distinguish between the 7th Amendment or Article 3 issue raised in Jarkesy and all due process issues that someone may have with the FCC's enforcement process. Jarkesy raises the 7th Amendment Article 3 issue. It's not a due process case. And so to the extent there are concerns about whether there are other due process improvements that could be made, that to me it does not stem from Jarkesy. In many instances, Tom might have written about this before Jarkesy's decision ever came down. A lot of the concerns that the industry has had with enforcement are longstanding concerns that are out there, and that is true of every regulatory agency that does enforcement that I've ever seen. The industry has concerns with the process. I don't think I've seen anyone yet that anyone says is absolutely perfect in any way, shape, or form. So from my perspective, when we sort of look at it and think about what you should do as an agency, you look at it. In looking at the law and Jarkesy and its prior precedent. By the way, I agree with the good professor that I will never seek to predict what this Supreme Court will do in the future. As he said, past precedent is not a guarantee of future outcome. And that's as true with the Supreme Court as it is with other things in life. But I will note that, I don't think that there are necessary reforms that need to be made as a matter of constitutional law. And, it may be that there are some waivers or consents that it would be advisable to obtain in settlements. And it may be that the appellate portion, meaning you pay the fine and then you can go directly to the Court of Appeals, that avenue might need to get, it might be advisable to review that in light of Jarkesy. But otherwise, the enforcement process continues as normal, and no company is required to go through the appellate process. Every single one can do the de novo. And I take Tom's point that maybe there are some courts out there that don't actually follow through on the de novo. I don't know, I'm not judging that one way or the other. What I do know is the Communications Act, Section 504, statutorily requires de novo. And if a court isn't actually doing that, that's an issue for appellate court review. That's not an issue that goes to the heart of the FCC's enforcement process. It goes to whether or not, an Article 3 district judge is complying with the law. And, maybe I'd add that to my list of reasons why it may not be good for companies to want to go to a district court, because as Tom points out, they might get a judge who's not actually going to give them, a de novo. Maybe it's better for them to be before the experts at the FCC.
Tom, do you have any thoughts on that? And we've just got about 5 minutes left, so let's leave some time.
Sure. I mean, just quickly, I can give you some insight into how I think the general counsel's office might look at something like this. This is one of those cases that has systemic government-wide implications. So, another one is Loper Bright, which just overturned Chevron deference. When I was general counsel, we were dealing with Kaiser v. Wilkie, which was looking again at the extent to which agencies got deference for interpretations of their own regulations. So when you have these sorts of issues that affect not just the FCC, but the entire federal government, typically the Department of Justice is involved. You might have some interagency calls in which everyone is sort of discussing like how they're dealing with this, or that there's some uniformity among agency approaches, because ultimately it's the Department of Justice that's going to need to defend a lot of these decisions in court, or at least co-sign them. I mean, the FCC in direct appeals cases does have independent litigation authority, but on some of these bigger picture legal questions, there's a lot of coordination with the Department of Justice. And then internally, I definitely think or hope that the General Counsel's office was involved in thinking about what are our takeaways from this decision. I suspect whether they produced some written work product or not, that they advised the chairwoman and the commissioner's offices of this decision. I'm sure they met with the Enforcement Bureau about this decision. And I think we already see in this recent order a preview of where they've come out. There's basically, two ways you can come out. You can say, we think that our approach is defensible under current law. We're willing to defend it if possible. I mean, so, sometimes you have reasons to want to take that more aggressive view and want to be able to take on litigation risk, even if it's there. And the other way you could say is, we're going to self-discipline ourselves in some manner. And finally, I mean, the commission often looks to outside help with these sorts of legal arguments. I mean, that's what the notice and comment process is for. That happens in its rulemakings all the time. And it's part of what may be drawing the commission, Police Commissioner Symington, to say, let's have an open proceeding to look at this issue as well.
President Pierce, any thoughts on this?
Yeah, just to, I agree with everything that Travis and Scott said on this point. I think all of those actions are important to take. I'd add just two other points. One is the Administrative Conference of the United States has already started to study this, and that's another body that may be in a position to contribute to the thinking about how agencies should address that. And then just my final point is, whatever else agencies do, they better hire a hell of a lot more lawyers, because every enforcement case now is going to be challenged based on Jarkesy. And one of the issues, that it may not be the only issue, but one of the issues in every one of those cases is going to be the extent to which the statutory cause of action, the regulatory cause of action, traces its roots to the common law. So that's going to require a whole hell of a lot of thinking and research and then preparation to do battle, because this is going to be, it certainly, I tell my students all the time, you may not hate this area of law, administrative law, but as you see the Supreme Court turning it all around, it sure is good for lawyers. You guys are going to have lots and lots of opportunities, whether you work for the government or against the government. You got lots and lots of opportunities to argue.
Well, I think that's going to be the last word. I want to thank you all for this discussion. I think it's been terrific and really has given some light to the issues and given us a lot to think about. And so thank you for that. Now I'll pass it back to Caroline at the Federalist Society.
Great. Well, thanks, Scott. And on behalf of the Federalist Society, I want to thank our speakers for the benefit of their time and expertise today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in. And with that, we are adjourned.